All right, everybody, let's get going. We're giving it a couple minutes to allow people to sign on. Um, but we'll allow that to go while I'll start some of the introductions. Thank you, everybody, for participating in this event. We're very excited about our panel. We've got a good one today. Um, I'll start by way of introductions. We've got Tim Deemer, who is the principal at Jacobson Deemer Law Firm in Detroit. Tim is a past chair of the Negligence Section and currently finishing his last year with us, down to days, weeks, or maybe a couple months as the ex-chair. So um, Tim is, of course, a long time appellate attorney, well known primarily on the defense side. And we thank Tim for donating his time and knowledge today. Next up, we have Chris Desmond, who is the chief appellate attorney at Johnson Law, also in Detroit. Chris is certainly recognized as a leading appellate attorney from the plaintiff's side and a leading voice in appellate law throughout the state of Michigan. Finally, we have Beth Whitman. Beth has an interesting background. It wasn't too long ago that Beth and I were working together while at MDTC. But after 21 years of doing defense-sided appellate work, Beth has switched sides about 3 years ago and is now working at the esteemed Mark Gronzato Law and using her talent and abilities to advocate on behalf of plaintiffs. So she can kind of, sit in between Tim and Chris and keep them at bay. So we have three of the top appellate lawyers in the state of Michigan here today. Very grateful for their time and their expertise. And we are looking forward to a very terrific, very informative luncheon session today. So with that, Chris, I think, no, I'm sorry, Beth, we are going to start with you, and you are going to tell us about the Davis case.
Yes, exactly. So the issue in this case, and this one was argued this term, we're going to talk about not only issues that were decided this term, but also upcoming issues. We're going to kind of end with that. Um, so the issue in this Davis case is whether the plaintiff's common law claims against BetMGM LLC, which is an online gaming website, the common law claims of fraud, conversion, and breach of contract, whether those claims were viable in this case. So the plaintiff played some online game, and she won a significant amount of money, approximately $3.3 million playing this online game. After she withdrew an initial $100,000, the defendant actually suspended her online account. They did an investigation into this, and it turned out that they determined that her account had been erroneously credited because there was an error in the game. And so they ultimately then closed her account. So she got the $100,000, and that was it. She then sued BetMGM, and she alleged fraud, conversion, and breach of contract. So the defendant brought a motion for summary disposition and argued that plaintiff's claims were actually preempted by the Lawful Internet Gaming Act. It's referred to it as LIGA, and that the Michigan Gaming Control Board had exclusive jurisdiction over all gambling disputes. So what's interesting in this case is that while this motion for summary disposition was pending, the gaming board actually, gave some information in this and said, actually, we don't determine the validity of these disputes between participants and our licensees, and we don't actually have the authority to adjudicate these disputes. Unfortunately, the circuit court granted summary disposition and held that LIGA did in fact preempt plaintiff's common law claims. And the Court of Appeals affirmed and basically agreed with the reasoning of the circuit court. The plaintiff then applied for leave in the Supreme Court, and the Supreme Court granted leave by order entered on May 29th of 2024. Uh, the oral argument occurred in April of this past year, or this year, and there was a unanimous opinion of the Michigan Supreme Court, which is a nice thing to see. It was issued, or was written by Justice Zara, and they held in this case that there was no clear indication that the legislature actually intended LIGA to abrogate any common law claims that would rise between a person and an online gaming licensee. They said, obviously the legislature can alter or amend common law claims, but they have to do so under no uncertain terms. And here that there just wasn't any evidence that that was exactly what was intended by the legislature. And they also held that the common law claims were not inconsistent with LIGA, so as to be prohibited by 432.3043, which provides that any law that's inconsistent with the act does not apply to internet gaming. So the Supreme Court ultimately reversed the judgment of the Court of Appeals that had affirmed the circuit court's grant of summary disposition, and they remanded the case back to the circuit court for further proceedings. So the plaintiff now gets to go to trial on her common law claims in this case and try to get some of her $3.2 million back. The other interesting thing in this too is that not only did the gaming board, or I'm sorry, the MGM say that it was incorrect that she had received this money, but they actually wanted the $100,000 back that they had also given her. So, so now she's going to go hopefully to trial in this case. So it's just an interesting little case, and it has a lot of money involved too, which is kind of fun.
All right, thanks, Beth. Appreciate that. I think we are going to pivot to Mr. Desmond, who is going to bring us up to speed on some of the latest and greatest involving governmental immunity.
Thanks a lot, Mark. I appreciate it. So we're going to talk about a couple different cases today that were at the Michigan Supreme Court on applications for leave to appeal, as well as one proposed rule change relative to governmental immunity that people have been tracking for a number of years now, actually. The first case I want to talk about is a case called Mark Goss versus the Department of Natural Resources. This might be a case that's familiar to people who have participated in these before or keep up to date with Supreme Court opinion releases, because this case has been at the Supreme Court previously. A few years ago, full disclosure, this is my case. A few years ago, this case was in front of the Michigan Supreme Court relative to MCL 691.1405, which is the motor vehicle exception to governmental immunity. It's a case in which my client was operating a snowmobile on a snowmobile trail in the Upper Peninsula near Sault Ste. Marie. The snowmobile intersected with a cross-country ski trail, and that intersection was controlled by a stop sign. The individual on the cross-country ski trail was controlled by the stop sign, and the person on the snowmobile trail had the right of way. And so on the day in question, there was an employee of the Department of Natural Resources who was operating what's called the John Deere Gator, sort of like a little four-wheeler trailer on that cross-country ski trail. He disregarded the stop sign. He entered the intersection, caused a collision with my client. Unfortunately, the DNR employee lost his life in that accident. He was carrying propane tanks and fuel tanks inside of that Gator. And so there was a very tragic explosion that took his life and that caused significant injury on my client. And so a number of years ago, this case was in front of the Michigan Supreme Court on the issue of whether that John Deere Gator is a motor vehicle for purposes of MCL 691.1405. And the court held that it was. And so it remanded to the Court of Claims, where this case is proceeding, to proceed forward with discovery, because it was the first responsive pleading from the state of Michigan. So we go back and we do discovery, and after discovery, the state moves for summary disposition again, this time on the issue of causation, saying that the plaintiff's causation theory was speculative and thus impermissible under Skinner versus Square D, the preeminent causation case that comes from our Supreme Court. And so the Court of Claims disagreed with that and denied the motion, but the Court of Appeals in a 2-1 decision agreed and dismissed the case, holding that causation had not been established by the plaintiff. We filed an application for leave to appeal to the Michigan Supreme Court, and I think this one has maybe flown under the radar a little bit because there was no grant of mini oral argument, there was no grant of leave. This was a kind of rare peremptory reversal by the Michigan Supreme Court, where they issued a 3-page order explaining that the Court of Appeals erred for the reasons explained by Judge Feeney in her dissent. Judge Feeney was really talking about what Skinner versus Square D requires of a plaintiff, and how the plaintiff in this case had presented evidence when when you view the evidence in the light most favorable, and you accept that all reasonable inferences have to be drawn in the plaintiff's favor, that there was sufficient evidence, particularly through plaintiff's expert accident reconstructionist, as well as a couple of law enforcement, neutral, independent witnesses, eyewitnesses who investigated this accident. And so they said that because the plaintiff's causation theory amounted to more than just a possibility, that there was enough to allow the case to proceed forward to trial. The reason why I think that this opinion, even though it's an order, I think sometimes orders get overlooked by practitioners because they think, well, an order is not an opinion. But what case law tells us is that orders carry the same weight of law as an opinion, so long as the reasoning of that order is capable of being understood. I think that Goss might be one of the more significant causation writings that we have from our Supreme Court in a number of years now. And the important thing about it is that causation from a governmental immunity standpoint, sometimes people look at governmental immunity and they're tempted to say, well, I don't do immunity cases, and so I don't need to worry about that. But the causation standard that applies to the motor vehicle exception is the same standard that's going to apply to your normal negligence cases. And so for the negligence practitioners out there, you should familiarize yourself with the Goss opinion, even if you don't do governmental immunity, because you could still find it to be assistive for you. I'm going to try. Oh, one other thing to note very quickly about Goss. Goss is now pending in the Michigan Supreme Court following that peremptory reversal. It was remanded to the Michigan Court of Appeals to consider a very narrow issue regarding the Snowmobile Safety Act, which is a portion of the Natural Resources and Environmental Protection Act. I don't think that that's an issue that many of the people viewing this today are going to be impacted by in the future. It's a statute that's only been addressed by a couple of opinions in its existence and its history. So it's not a very big issue, but it's pending in the Michigan Supreme Court now for a 3rd time on that application. So we'll see if the Supreme Court needs to take up Goss again. It's probably not a bad idea to transition from Goss into the proposed rule change that I was discussing, because it kind of speaks to why the Goss case is where the Goss case is. Goss was a case that was filed it was either 2018 or 2019. And so this is a case that I've been working on now for 6 to 7 years, and we've never had a trial. We don't have a trial date. And the reason for that is in part because of the court rules that allow governmental defendants to take interlocutory appeals as a matter of right when a motion invoking governmental immunity is denied. And so unlike most private actors who have to file an application for leave to appeal if they want to go to the Court of Appeals on an interlocutory basis, governmental defendants have a right by virtue of our court rules. Some judges in the Court of Appeals had started to call for this right to be re-examined a few years ago. And so there was a proposed rule change put out that was submitted through the Michigan Supreme Court's website for public comment. And there was a significant response to that invitation for public comment, with a lot of people writing to the Supreme Court on the defense side and the plaintiff side about their view of this rule and whether it continues to make sense for Michigan. There hasn't been any action on that rule, but my understanding, just so people know, because I think there are a lot of people curious about this, that process is not dead yet. And so at the Michigan Appellate Bench Bar Conference this past May, I had asked a question of a Supreme Court employee during one of the plenary sessions about the status of that rule change. And I was told that it was essentially still within the committee that's doing research regarding it. And so there could be future movement on that rule change, even though it seems like it is maybe stalled out a little bit. From there, then the next significant thing to talk about in governmental immunity, and again, this was a case of mine, and it's not one that I love to talk about, but it's the cause of action that arose out of the Oxford school shooting that occurred in November of 2021. Now, I don't know whether or not Beth is going to want to offer some comment on the Oxford case as well. Beth and Mark Granzato had a client that they represented whom they had filed an application for leave to appeal to the Michigan Supreme Court on behalf of. I have several clients that I filed an application on behalf of. And this is following a loss in the Michigan Court of Appeals. And so people understand a little bit about the context. I know people are obviously familiar with the underlying event, which I'm not going to discuss much. But in terms of the legal theory of the case, we had brought suit, as had a number of others, under Michigan law. There was also a federal lawsuit, but the Michigan lawsuit was pursuant to MCL 691.1407, which people kind of think of as like the gross negligence exception to governmental immunity, even though that's not quite what it is. But this is a section of the Governmental Tort Liability Act that allows for individual governmental employees to be sued when their act of gross negligence was the proximate cause of the plaintiff's claimed injuries. I kind of hate that I just said the proximate cause as opposed to the proximate cause, because this is sort of what all of this case law hinges around. For years after the passage of that statute in 1986 by our legislature, the term the proximate cause that's present in that statute didn't carry any significant meaning. There was case law in the form of a case called Daydays versus Ash from the Supreme Court that said the word the and the word are interchangeable for statutory interpretation purposes. And so the legislature's use of the word the in MCL 691.1407 didn't carry any significance. In 2000, the Michigan Supreme Court reversed the decision in Daydays in a decision called Robinson versus City of Detroit, which is a very significant Michigan Supreme Court decision in the world of governmental immunity. And so in the Oxford case, we were taking on the decision in Robinson versus City of Detroit, arguing that in that case, the Michigan Supreme Court incorrectly held that the term the proximate cause requires a plaintiff in a governmental immunity case to show that the defendant was the one most immediate, efficient, and direct cause of the plaintiff's injuries. That application was put before the Michigan Supreme Court, I believe on Halloween of this year. It was filed. The Michigan Supreme Court denied leave to appeal in both of those applications, simply saying, as it often does in these orders of denial, that it didn't believe that the questions presented by the appellants should be addressed by this court at this time. I think that when it comes to something like this session, one of the values in it is, to the best of our ability, kind of prognosticating or giving some insight to the viewers about what the next steps are in these different areas of law and where the Supreme Court could be going in the future. I think it could be tempting to read into the denial of leave in Oxford as sort of a closing the door on challenges to the rule from Robinson versus City of Detroit. There have been a number of challenges to that decision over the years. I don't think that that's the proper way to read what the Supreme Court did, frankly. I think that the Oxford case, when looking at it objectively, the Oxford case carries certain features about it that may have been the deciding factor for the Supreme Court. And what primarily stands out to me is that it involves intentional criminal conduct by a third party. And so in the typical proximate causation fight with a governmental defendant, you're dealing with two negligent actors. And so this one was a little bit atypical when we think about what these cases look like in the Supreme Court. And so I guess my takeaway from the Oxford case certainly isn't that individuals who have an interest in challenging the rule from Robinson should give up that fight. I don't think that that's the message. I think that there's still room for meritorious argument about whether or not Robinson was properly decided. I think that that is a question that will be addressed by the Supreme Court someday, but they unfortunately didn't believe that Oxford was the best vehicle in which that they could do it. Beth, I don't know if you have any additional thoughts on Oxford. But if not, I think that is essentially the update on governmental immunity. I think that people should keep their eye on that Goss case because that could get taken up for a third time on a very narrow issue. But beyond that, there weren't opinions of major significance this term relating to governmental immunity. It was more the lack of action that was notable.
Yeah, exactly. And I think with that court rule change too, like, well, I think everybody's kind of still waiting and watching and just to see what happens. It's a big deal because, like you said, these cases get up in the appellate courts, sometimes on a motion, a C8 motion, and they may not end up back in the trial court for years and years and years. And then you get a C10 motion and you're right back up. So
Yeah, yeah,
it's a difficult thing. It's a
you
difficult.
do. And one thing, not to sort of thrust ourselves back into the public comment phase on that rule, but there are real practical consequences for that rule because what happens, one of the last opinions of significance from the Supreme Court on this gross negligence issue in Robinson was our case called Ray versus Swagger. Ray was a case that was litigated for 8 years, and it was almost exclusively in the appellate system. We never went to trial in Ray. It settled after the Supreme Court decision, but it still took 8 years to litigate. And when we think about injured individuals, sometimes these are people who can't work for that entirety of that 8-year window, and they're trying to make it through until they can get a remedy from the court that they filed suit in. And when it takes a long time, it can be difficult for those individuals to endure. And so that's sort of what's at the root of this court rule and this urging from certain individuals to modify that.
All right. Thank you, Chris, for that. I think we are turning the floor over to Mr. Deemer and the Rayford case.
Thank you, Mark. Before I begin, I got one slight correction to the introductions. The law firm formerly known as Granzato Law is now Granzato Whitman. So just to give Beth.
I know. I realized just today that it's still listed as Granzato Law on the State Bar website, so I had to make the change.
I was on Google. That's what I saw on Google. So
no, I appreciate that. Thank you.
And then just kind of dovetailing with something Chris said, that there weren't any blockbuster decisions this past term on governmental immunity. I think it's safe to say that there weren't blockbuster rulings on any real issue, at least compared to what we've seen the last few years. I think it was 2022. We had the Supreme Court weigh in on whether the reforms to the No Fault Act were constitutional in the Anderi case, which was a blockbuster case. The following year, we had the El Said decision, which overturned 20 years of precedent on premises liability and created a new standard. Last year we had Daher, which was a major wrongful death decision. This term has some important opinions that came out, but I don't think they rise the level of those three, the importance of those three decisions, which were groundbreaking and game changers for Michigan attorneys. So I think it's safe to say that no major governmental immunity issues. And some of the other cases we're talking about, they're important, but they're not going to rise to that level. My first case for me to discuss is Rayford versus American Homes. This might turn out to be a blockbuster decision. We're not sure just yet what this case actually means because the case itself is pretty narrow and fact specific, but I think it might, again, foreshadow some major changes in Michigan law. But it's also a continuation of trend that we've seen in recent years. The Supreme Court has been more flexible in medical malpractice cases, and some of the procedural requirements that a plaintiff must meet to get the case in court or defense has to raise to mount a defense. There's been a kind of a softening on some of the strict rules that used to see cases dismissed or defenses rejected based on a failure to strictly comply with the court rules and the statutory requirements. That has been softened. We've seen softening in just general rules of pleading and amendment back doctrine. Expert witnesses, not so strictly enforced. What Rayford versus American Homes signals, I think, is a softening of the rule of contracts. I passed the bar in 2002, and until very recently, our state was staunchly in favor of freedom of contract, where contracts were enforced as written, no matter how lopsided the bargain might have been, no matter how disparate the bargaining power of the parties might have been. It didn't matter. If you signed an agreement, we applied the plain language, no matter how unfair it might be. The epitome of that rule was Rory versus Continental Insurance, where the court enforced a shortened limitations period for an uninsured motorist claim. Mr. and Mrs. Roy, I can't remember, had a uninsured motorist policy with Continental Insurance Company. And rather than the 6-year limitations period that applies to breach of contract cases, the insurance contract had a 1-year limitations period. And the Supreme Court enforced it, again, under freedom of contract principles, expressing reluctance for the judicial system to weigh in on the reasonableness or fairness of a contract. The rule was if you sign the contract, you're stuck with it. That has been the law for a very long time here in Michigan, and Rayford signals a potential retreat from that rule. The Rayford opinion, it was a shortened limitations period in an employment contract. Employee started a job, signed an employee handbook that provided for a 6-month statute of limitations period, as opposed to 3 years she would have had for a civil rights claim generally. She was fired from her job. She believed she was discriminated against and tried to sue, but the 6-month limitations period foreclosed her claim. And that was affirmed in the Court of Appeals. It got to the Michigan Supreme Court. And what the Michigan Supreme Court held was that the Rory decision is not being overruled. It's still there in place, but it does not apply in any context other than an insurance policy. And the court gave basically 2 reasons why Rory was going to be limited to insurance contracts only and not employment contracts. One is that insurance contracts are reviewed by the insurance commissioner, the Department of Insurance Financial Services, for reasonableness. If an insurance contract has an unreasonable term, DIFs and the insurance commissioner have the authority to strike that provision from the insurance policy. There is no equivalent for employment agreements. It just does not exist. So part of the reason the court again softened the rule and held that Rory applies to insurance contract is because there's an independent review for reasonableness that exists. Now, a little bit later, there's another case we're going to talk about where the Supreme Court basically overruled DIFs and said, DIFs, your guidance, your interpretation of the statute's wrong. We're not going to follow you. So that's a little bit of exactly how that's going to unfold, where the court will overrule DIFs and ignore DIFs, but then in this case, acknowledge that DIFs performs a reasonableness review, which is sufficient, unlike the employment agreement. And the other major focus for why Rory was limited to insurance contract was the importance of employment. People can't feed their families, can't take care of themselves without a job. So there's added protection that's going to be applied to the employment context. And the Supreme Court confirmed that an employment agreement that would limit the time to file a lawsuit is going to be strictly reviewed by the judicial system to make sure that the plaintiff would still have the opportunity to pursue a claim if they've been wronged. The other interesting thing from the opinion, in my view, is that the court really stressed that it's a case-by-case basis. There's no one-size-fits-all approach to what is reasonable. And the court specifically noted that what might be reasonable for one disgruntled former employee would be different for a different employee. If the example that was cited was, what if the disgruntled employee, the terminated employee had mental health issues as a result of being terminated or something terrible happened at the workplace? They might need more time. They might not be treated the same as someone who doesn't have the mental health issues. The court distinguished your average hourly employee with a corporate CEO who gives up certain rights and remedies in return for a different stock option. They'll be treated differently than your minimum wage employee who's on an hourly basis. It's really going to be an individualized inquiry. And if one judge says 6 months reasonable in this context, it might not mean anything to a different judge in a different context. And that's another major shift in our jurisprudence, where it's not, again, the one-size-fits-all approach. We're going to have individualized inquiries. I would contrast that with prior open and obvious decisions that we had in Michigan, where it truly was a one-size-fits-all approach. Was this hazard open and obvious to a reasonable person, not this particular plaintiff? And we saw how far that doctrine went when open and obvious doctrine was applied to a blind person. And the rationale was the standard is not, was it open and obvious to this particular person who is blind or this person who has 20/20 eyesight? Was it open and obvious to a reasonable person? We don't get into individualized inquiries. And Rayford stands for the exact opposite proposition. So we'll have to see how far that individualized approach principle from Rayford's applied in other contexts. There were two other things of note. One, there was a concurrence by the Chief Justice, Megan Kavanaugh, which is more of an academic point. She opined separately on whether this decision in Rayford truly was overruling prior precedent, or whether it represents carving out an exception or a distinction from the Rory decision, and whether carving employment agreements out from the rule of Rory is truly overruling Rory, or is it carve out? And I think that's an academic point, but at the same time, if you find yourself going to Michigan Supreme Court and you can say, hey, we're not trying to overrule precedent, which is a revolutionary type of an act, but we're trying to create a carve out, you might not have those same hurdles that go into overruling precedent. There's a whole separate analysis. So just I think a practical point, if you're going to the Michigan Supreme Court and think your case is different, frame it as a carve out as opposed to overruling. And then the other really interesting thing from this opinion is there is a 62-page dissent by Justice Zara defending the Rory decision. And the majority opinions said time and time again, we're not overruling Rory. Rory's still good law. It still applies, but only in the insurance context. And Justice Zara, despite those reassurances in the opinion, still went out and wrote this, again, very lengthy, well-reasoned, extensive, researched dissenting opinion against the rule in Rayford, but also chastising majority for retreating on principles that have been in Michigan law for a good amount of time, and also trying to vindicate those principles from future attack. I think when this case came out, the word on the street was, is Rory next? Are there other examples where freedom of contract is going to yield to reasonableness? My final comment, I will close with a quote, and I think this quote is an important quote for the decision itself, but then it also for purpose of our section. And the court's opinion kind of waved the flag of the statute of limitations and what it means for a plaintiff, but what it means for a defendant. And its negligence law section is equal plaintiffs, equal defendants. I think that's a good quote to end with. It's on page 29 of the opinion. And this is, again, exploring the virtue of statute of limitations for all litigants. The difference between an employee having 3 years to file a lawsuit as opposed to just 6 months cannot be understated. Prospective plaintiffs and defendants both depend on the reliability and consistency of a statute of limitations when planning for and moving forward with a case. Plaintiffs depend on the time provided in statutes limitations to gather evidence, hire an attorney, and in some cases even realize they have been injured. Meanwhile, defendants trust that after the time period set forth in a statute of limitations has run, they will no longer have a potential case looming over them. That's kind of the public policy pitch that Justice Welch's opinion cited to towards the end of the opinion.
All right, Tim, thank you for that. Interesting case for sure. I believe we're moving on to Beth and the Markle case.
Yes, so this is Markle, I'll call it Markle 2, but I think it's, maybe Markle 4 at this point, if you count the Court of Appeals decisions. But this case also has been up and down in the courts. I discussed it previously at our spring seminar for the negligence section. So the issue in this case, again, the Supreme Court addressed a hospital's liability for a physician who's practicing in the hospital where a patient seeks treatment from the hospital through the emergency room and is treated during their hospital stay by a physician with whom they have no prior relationship. So, the history in this case involves the 1978 decision of the Supreme Court in Grew versus Mount Clemens General Hospital. In that case, the Supreme Court established the ostensible agency liability in a hospital emergency room setting and set up the three-part test for an ostensible agency claim. The first prong of that test is really what was at issue in the Markle decision. The person dealing with the agent, in this case, it would have been the physician, must do so with the belief in the agent's authority, and this belief must be a reasonable one. So the facts of this case, Ms. Markle comes to the hospital through the emergency room for treatment. She sued ultimately Beaumont Hospital and Dr. Lonapin, who was a physician who provided care and treatment to her while she was in the hospital during her stay. Dr. Lonapin was a hospitalist, so he only saw patients in the hospital setting. And Dr. Lonapin was assigned to Ms. Markle's case actually based upon an arrangement that existed between Ms. Lonapin's primary care physician and Dr. Lonapin's basically practice group to provide treatment for the primary care physician's patients who presented to Beaumont Hospital. So the plaintiff alleged that Beaumont Hospital was in fact vicariously liable for the malpractice of Dr. Lonapin. Beaumont moved for summary disposition as to the vicarious liability claim. The trial court ended up granting summary disposition. And one of the things that it noted is that Ms. Markle actually had no recollection whatsoever of Dr. Lonapin. So it found that there was nothing to support a claim that the plaintiff had a reasonable belief that Dr. Lonapin was in fact an agent of the hospital. So the Court of Appeals affirmed the grant of summary disposition in an unpublished decision. The plaintiff then sought leave to appeal in the Supreme Court, and the Supreme Court granted leave. The initial holding in the case, the Supreme Court issued an order reversing the Court of Appeals. That was, I guess, Markle 1, I'll call it. And they held that the critical question that was identified in GRU is whether the plaintiff at the time of the admission to the hospital was looking to the hospital for treatment or was merely looking at the hospital as the site where his or her physician would treat the patient for their injuries. So the Markle court said, consistent with the GRU opinion, that a patient who has either clear notice of a treating physician's actual employment status or has a pre-existing relationship with that physician, they cannot reasonably assume that a physician then is an employee or agent of the hospital just because the treatment is provided within that hospital. But when a patient presents for treatment in a hospital through the emergency room and is treated during their hospital stay by physicians whom they have no prior relationship, then it's reasonable for them to have a belief that this is the hospital's agent, unless the hospital does something to dispel that belief. The court also rejected the Court of Appeals holding that because the patient couldn't remember Dr. Lonapin, that she could not have formed a reasonable belief that the doctor was the hospital's agent. So the Supreme Court ultimately remands the case back to the Court of Appeals for reconsideration under this appropriate standard that they have indicated in Markle 1. So the Court of Appeals then issues an unpublished decision in January of 24 on remand, in which they again affirm the grant of summary disposition. So the majority in that case held that agency by estoppel requires proof that the plaintiff actually relied upon the representations made by the hospital as to the status of its agent. So the majority found that for plaintiff to prevail under GRU, she must show that she relied upon Beaumont's representation through the operation of the emergency department that Dr. Lonapin was its agent. So the court held because there's nothing in the record that indicated that Ms. Lonapin had in fact relied upon any representation that Beaumont was Dr. Lonapin's principal, then the court concluded that the trial court properly granted summary disposition. So the court then goes back up to, the case goes back up to the Michigan Supreme Court, and the Michigan Supreme Court granted a MOA by order entered on 9/11 of 24. The Supreme Court held oral arguments in this case in April of this year, and they then issued an order on July 9th of 25, reversing the Court of Appeals decision. They rejected the Court of Appeals decision injecting this reliance requirement. I think this was one of those where they were like, that's not what we said. We said what we said in Markle 1, and They said that plaintiff had in fact demonstrated a genuine issue of material fact as to Beaumont's liability. Um, Plaintiff again presented through the emergency department and was treated by a doctor who she had no prior relationship with. And they indicated too that Beaumont didn't set forth any facts that as a matter of law dispelled that belief or that reasonable belief that Dr. Lonopin was in fact an agent of Beaumont Hospital. And, one of the other notes that the Supreme Court made too is that even though there was this existence of this agreement between Dr. Lonopin's group and the plaintiff's primary care physician, the plaintiff didn't know anything about that agreement. So that didn't do anything to dispel any sort of reasonable belief or any reliance upon the I can't think of the word I'm trying to say it. I'm sorry. It didn't dispel any reliance either. Okay, so the Supreme Court ultimately then reversed it flat out, didn't remand it back to the Court of Appeals, just remanded it back to the trial court for further proceedings. So again, this is a case that's been up and down in the courts and now finally is going to be back in the trial court for additional proceedings and, set for trial.
Thank you, Beth. Another interesting case, particularly for our med mal folks.
Yeah, exactly. Yeah, because these claims, I think now, I think are likely going to go to trial in these cases. I think it's this decision by the Supreme Court, I think makes it pretty clear that that's what's going to happen in these cases. It's generally going to be seen as a question of fact as to whether a sensible agency exists under these circumstances.
Create a whole other opportunity for more years of appeal, right?
Exactly. Yes.
All right. Thanks, Beth. I believe now we're going back to Chris. Chris, and my notes are a little unclear. Did you want us to talk about Beaubien or Bowerman?
Yeah, we're going to talk about Beaubien first, Mark. And this
Great.
one honestly could turn into more of a panel discussion because I think everybody on this panel has some connection to Beaubien, or at least the issues in Beaubien. So Beaubien was my case. Tim was amicus, I believe. Tim, you can correct me if I'm wrong. Tim was amicus on the other side for me. And Beaubien involved a case that it's a medical malpractice case that went to trial, kind of a rare diversity medical malpractice case. And so it went to trial in federal court in the Eastern District of Michigan in front of Judge Drain. It was tried by two attorneys in my firm, Paul Doherty and Ken Cara. They tried that case to an $8.6 million verdict in front of Judge Drain. And when it was time for entry of judgment, the defense was attempting to impose the caps that are located at MCL 600.1483. The medical malpractice caps, which the statute, for those who aren't aware, contains a low cap and a high cap that caps the damages, the non-economic damages that a plaintiff in a medical malpractice action may collect following verdict. There's a court rule in Michigan, MCR 7.308, that allows for the certification of questions to the Michigan Supreme Court if there's a question in front of a federal court that it believes has not been fully answered by the Michigan Supreme Court previously. And so when the defense moved for entry of judgment in Beaubien, we opposed that entry of judgment and asked for the district court to certify the question of the constitutionality of Michigan's medical malpractice damage caps to the Michigan Supreme Court. We argued that the Michigan Supreme Court had never addressed that issue before. The Michigan Court of Appeals had, but the medical malpractice cap specifically had not been addressed by our Supreme Court before. Judge Drain, following briefing by all parties, agreed with us and decided, yes, this question hasn't been answered before. I need to know whether or not Michigan's medical malpractice caps are constitutional before I can enter judgment in this case. And the Michigan Supreme Court is the court that should pass on that question first because it's an important question of state law, not federal law. So Judge Drain certified the question to the Michigan Supreme Court, and the questions essentially involve different theories of why those cap provisions violated the Michigan Constitution. We argued primarily that it violated the right to a jury trial, which is very relevant to this section's work, obviously, because it's one of the fundamental principles of this section is the belief in the right to a jury trial. We argue that it violates the right to a jury trial because the caps prevent juries from actually determining the amount of damages that are going to be awarded to a plaintiff, and having their verdict effectuated through a judgment. We argued that it violated the right to equal protection in Michigan because victims of medical malpractice, frankly, were being treated differently than victims in other types of cases. And we argued that it violated the separation of powers between the legislature and the judiciary because the caps represented an instance where the legislature was controlling judicial action through legislative acts. So the case was sent to the Michigan Supreme Court on that certified question by Judge Drain, and it was briefed extensively. One of the interesting things, so there's not a lot of precedent for certified questions in the Michigan Supreme Court. It's not something that comes up that often, and so it's not a procedure that there's a big track record for in terms of what the court will do. The court essentially had a world full of options at its disposal when Judge Drain certified the question. It could have, after briefing by the parties and the extensive amicus briefing that was submitted, it could have issued an opinion right then without oral argument telling us whether it thinks caps are constitutional or not. It could invite the parties to have oral argument and supplemental briefing or additional briefing like it would in a normal like leave app grant situation. And it could also just say, we're not going to answer the question. We knew that that was a possibility, that they didn't have to answer the question. And so one of the things that was briefed by all sides was whether the court should even address this question, almost addressing like the validity of the certified question process. For people who are curious about that process, although I think the court's action in this case maybe doesn't foreclose future use of that rule, but it might slow people down who are looking toward that rule. But for people who are interested in sort of this debate about the legitimacy of the process, in the early 2000s, there's a lot of opinions from the Michigan Supreme Court in that phase of time addressing certified questions. And it's interesting because it's one of these rare instances where we had a cross-party lines in the early 2000s dispute between two members of the same party. So Justice Young was very opposed to the idea of the Michigan Supreme Court taking issues on a certified question basis. Justice Markman believed deeply in the process, arguing that it represented essentially comity between the federal courts and the state courts. When a federal court judge is concerned or confused about an issue of state law, our courts should be encouraging them to have this open dialogue with our Supreme Court. And so this was an open debate in the early 2000s. In our case, ultimately, the Supreme Court decided that it was not going to answer the certified question. Justice Bernstein dissented. He stated that he would have the court answer the question and he would hold oral argument on the question. Justice Kavanaugh, Chief Justice Kavanaugh, wrote separately. She concurred in the decision to not answer the question. And she wrote separately to explain that essentially what motivated her, my reading of it is, what motivated her to not answer the question at this stage is that she doesn't like the certified question process, that she doesn't think that this issue should have come to the court through the certified question process, as opposed to coming up, for lack of a better term, sort of organically through our appellate system, starting in a circuit court, going to the Michigan Court of Appeals before the Michigan Supreme Court passes on the question. And so the Michigan Supreme Court elected not to answer the question. While Chief Justice Kavanaugh wrote what she wrote, the law of the case essentially is just that the court decided that it wasn't persuaded for the need to answer the question at this time. And so now the case goes back to Judge Drain, and it's in a position where there's a federal judge who has declared to the Michigan Supreme Court, I don't know whether caps are constitutional because you've never told me before. And that remains true. He still hasn't been told by the Michigan Supreme Court whether those caps are constitutional or not. And so it remains to be seen what the judgment in Beaubien ultimately will reflect and what the future steps are. Tim, I don't know if you wanted to offer any comment. I know you filed an amicus brief. Who was it on behalf of? It was one of the hospitals, correct?
It was behalf of Corwell Health and McLaren. It was
Okay.
and I'm happy to chime in, but I mean, Chris covered it, objectively And I'm going to start with crossing out all the things I was going to say that Chris adequately covered. I had the same thought, Chris, about how there was a dispute back in the day whether this procedure was even constitutional or not to give advisory opinions. And I think this is a pretty clear indication that the current court is open to certified questions in the right case, and they found this was not the right case. And I also thought, kind of similar to how Chief Justice Kavanaugh's concurring opinion in Rayford explained, well, was this actually overruling precedent? Was it a carve out, kind of a procedural angle, which I think is extremely helpful to appellate practitioners. The concurring statement here is also extremely helpful to appellate practitioners. It was not necessary for her to chime in, but it's extremely useful and helpful. Usually a denial of leave to appeal or certified question, there's no explanation. Just you failed to persuade us that we need to address this question, and that's it. It's rare to get an explanation as to why. And this, I think, is an extremely helpful explanation as to why. And I think it also helps the procedure and substantively, because the Chief Justice statement said, even though there's not a Michigan Supreme Court opinion on medical malpractice plaintiff versus medical malpractice defendant saying the Section 1483 is constitutional, we as a Supreme Court have addressed and confirmed the constitutional damages caps in other contexts. The damages caps in products liability statutes, the damages caps applicable to the lessor of a motor vehicle. The Supreme Court has said those damages caps are constitutional, and the Chief Justice statement said that's not good enough's not the right phrase, but that would also affirm the caps of the medical malpractice statute. So I think in addition to the procedural aspect, I think what that signals is the current court, I think it's correct, views the constitutionality question to be the same, whether it's med mal, product liability, vehicle leasing, or any other context where the statutory damages caps, it's the same analysis, the same challenge, the same review. So there are pending cases in the appellate system on damages caps and medical malpractice, but that medical malpractice damages caps constitutionality might be decided in a products case or some other context. So I don't think this is limited to just medical malpractice. This challenge could arise in some different context where we've got a similar type of an issue.
Yeah, so it's, I mean, I generally agree with you, Tim. Generally agree with
This
you.
is recorded, right, Chris?
Well, yeah, so that's why I'm going to definitely put that qualifier in there that it's generally, because I always have to reserve some room for disagreement with you. But yes, we have a statement from Chief Justice Kavanaugh that, it's a thorough statement. It's exactly what Tim just said it is. I'm not saying that the other members of the court don't agree with it, but other members of the court didn't sign it. And so then it leaves you as an appellate practitioner and as an audience, frankly, the people who are watching this, in a position where I don't know. I don't know what you take from it. I don't know what your conclusion is. If you have either, I guess there are two issues that I think are implicated by Beaubien that are important for people. One, whether or not you're going to use the process that we used in this case, the certified question process. And just to be clear, it was the only process we had available to us. We're in federal court. We can't get the Michigan Supreme Court to tell Judge Drain this is unconstitutional without the certified question process. But I think Beaubien sort of maybe has some lessons for people who want to use that process. And then there's also the question of, well, like Tim said, there are other cases in this system right now in the state appellate system that deal with possibly the constitutionality of medical malpractice caps. Where do those cases go? My personal opinion is that there is more room for argument about medical malpractice caps being unconstitutional than there is for the certified question process. I would be very hesitant as a practitioner right now, after my experience, frankly, to employ the certified question process unless you really need to, like we did in this case. But when it comes to challenging the constitutionality of caps, I think that there's still room for that argument. Still hasn't been addressed by our court, although Tim is right. It's been addressed in other contexts like products liability. And there's certainly an argument that if a products liability cap is constitutional, so is a medical malpractice cap. The only thing that I would maybe caution people on a little bit when it comes to that reasoning is when we talk about constitutionality, there are tests that apply, right? You've got the rational basis test, you have the strict scrutiny test, and involved in both of those tests is this idea of, well, what was motivating the legislature when they acted in this area. And so you could have different motivations that are valid when it comes to products liability or leasing of vehicles that doesn't necessarily pass constitutional muster in another area like medical malpractice caps. And so I don't think people who have these cases should be dissuaded from making these arguments going forward in the future. But this was clearly, undeniably, an opportunity for the Michigan Supreme Court to be able to head on address whether these are constitutional, and they chose not to. So, and then Mark, I think beyond that, so I think that's it on Bobian, unless Beth has anything that she would like to say on it. I know obviously her firm does extensive medical malpractice work, and I think has been involved in making similar arguments in the past. But if we don't have anything else to say about Bobian, I think next we're going to transition into the Bowerman case, Mark, that you had referenced before. And
Yeah.
so for the remaining use of time, other than answering questions, if there happen to be any by the time we're done, for the remaining use of time, Tim and I are both going to discuss, things that are coming in the future, and then a couple smaller issues that were in front of the court recently. The first one we're going to discuss is the Bowerman case. Bowerman is a case of mine that is going to be argued in the Michigan Supreme Court this upcoming term. Leave was recently granted right before the end of this past term. Bowerman is a case, just to give you a quick idea of the facts. My client, Jan Bowerman, is an elderly woman who lives at a residential facility that is exclusively for the elderly or the disabled. There's a dumpster at the apartment facility. This is sort of an L-shaped apartment building with a parking lot that sits in that L area, that internal area. And there's a dumpster at the back end of the parking lot that all residents have to use to throw out their garbage. And so my client was attempting to take her garbage out. There was some concrete and asphalt work that was being done throughout the facility that involved tearing up both sidewalks and parking lots to relay new concrete, new asphalt. My client was out in the early morning hours while it was still dark outside. There was a dimly lit parking lot that she was trying to traverse to take out her garbage. She encountered, unbeknownst to her, a several inch deep trench that was several feet long that ran the length of the dumpster in front of the area where her garbage disposal was. And in the process of trying to access that area, she steps into this trench. She suffers significant injury that I believe kept her confined to a wheelchair for a lengthy period of time following this accident. And so we brought suit initially against the landlord under MCL 554.139, which this is kind of commonly referred to as the landlord tenant statute. For people who aren't familiar with it, it's a statute that imposes into each residential lease a covenant, several covenants. The one that's at issue in this case is that all common areas of a facility will be fit for their intended use. And so we argued that the common area in this case, the walkways that lead up to this dumpster, and the dumpster the garbage disposal area itself were not fit for their intended use, and it caused my client injury. We also brought a negligence cause of action against the contractor who was present at this facility doing this concrete work. The evidence tended to show that there were no cones, there was no tape that was guarding off these trench areas, these open areas, and that defendant admitted that they knew that it constituted a hazardous condition, a trip hazard for the residents of that facility. And so at the circuit court stage, the circuit court, this is pre-Candle El Said. So this is kind of a procedural mess, this case. But this is pre-Candle El Said while we're in the summary disposition stage. And the circuit court said, well, your negligence claim against the contractor, because it involves a hazardous condition of the land, it's really a premises liability claim. And I think that this was an open and obvious hazard. And so I'm granting summary disposition. It then determined that the common area was fit for its intended use. And in reaching that determination, the court relied on a pretty major opinion that a lot of viewers, I think, will be familiar with, which is Allison versus AEW Capital. Allison is the seminal case that talks about this statutory provision regarding fitness for its intended use. Allison was a case from the early 2000s in which the plaintiff was attempting to access their vehicle that was parked in the parking lot at their apartment complex. and the parking lot was covered in snow and ice. And the plaintiff, in attempting to access their vehicle, slipped and fell. And when they argued this statute, that their parking lot wasn't fit for its intended use because they couldn't walk to their vehicle, the Michigan Supreme Court explained, in essence, that the purpose of that common area, the parking lot, was to park and drive vehicles. And so because the snow and ice didn't interfere with the ability to park and drive vehicles, that statute wasn't implicated and the plaintiff had no cause of action. So in reliance on that, our circuit court did the same thing here and dismissed our cause of action. By the time we were on appeal, Kandil El-Sayed had come out. And so we argued to the Michigan Court of Appeals, well, certainly an open and obvious ruling requires remand now, because we know under Kandil El-Sayed that's no longer the rule. The Michigan Court of Appeals did not agree. The Michigan Court of Appeals, and by the way, we also argued this isn't a premises claim. Open and obvious isn't even an available defense in this case, because the open and obvious defense when Kandil El-Sayed, before Kandil El-Sayed had issued and when Lugo was still good law, the premises liability defense required that the defendant in question be in possession and control of the land. And our argument was this contractor wasn't in possession and control. They're not liable by virtue of their possession of the land. They're liable by virtue of their negligent act on someone else's land, and that's actionable by itself. The Michigan Court of Appeals disagreed. They held that this does arise out of a hazardous condition on the land. And so when they analyzed it from a premises liability standpoint, they basically treated it like it was an open and obvious hazard. They then addressed separately whether or not this contractor could be held liable for their acts of negligence, seemingly recognizing that a contractor does have a duty when they're on the land of another. But they held that there was no liability in this case. And then when it came to the landlord-tenant statute, they again held that this was generally fit for its intended use and that there was no liability. We filed an application to the Michigan Supreme Court, which has now been granted. The Michigan Supreme Court has granted that application to address two questions. The first is whether or not the defendant contractor breached a duty that it owed to the plaintiff. So a very broad question that I'm going to get back to in a moment. And the second is whether or not the landlord violated MCL 554.139. Some of the cases that I want people to think about a little bit, if they're hearing this and they're thinking like, when could this become relevant to me? If you look at cases like Allison versus AEW Capital, but also cases like Fultz and Lewecki. Fultz was a very big case from the Michigan Supreme Court earlier in the 2000s that kind of caused a lot of headaches for a lot of people, because Fultz involved a contractor, a snow removal company that was supposed to be on the land of another to plow snow. That contractor failed to show up, and so they never did anything. And when the plaintiff got injured and sued, the holding of the Michigan Supreme Court was basically like, well, while a contractor would have a duty to use reasonable care if they acted, this contractor never acted. They never performed their contract. Since you're not a party to the contract with them, plaintiff, you don't have a cause of action against them. Maybe the co-party to that contract would have a breach action, but you don't have one for personal injury. In this case, we're going to be arguing that Fultz isn't really implicated here. That rule of Fultz isn't implicated because we have a contractor who did take action, who was on the land, who did something that they essentially acknowledge created a hazardous condition on the land. And so the question for the court is more along the lines of what duty is owed by a contractor when they create a hazardous condition on the land of another that they are not in possession or control of. So Allison versus AEW Capital is a case that's going to be implicated by this. The Finazzo case, which is a premises liability case predating Kandil El-Sayed, that deals with the issue of when is a contractor in possession and control of someone else's land. That's potentially implicated by this fact pattern. And I would anticipate that we'll probably have oral arguments sometime early within this term regarding these issues. And I think that's it on the Bowerman case. Tim, I think that you were now planning on discussing a selection of orders and upcoming cases. Is that right?
The smorgasbord conclusion.
Yeah.
But, you know, as we started with, this wasn't the blockbuster term like the previous terms. So we might not go the full 90 minutes. So that does leave plenty of time for any questions that you attendees might have of the panelists. Or Mark. I know Mark's dying to answer some questions about these opinions, so make sure to direct them to Mark. Kidding aside, so I'll address two other decisions that the court issued in this past term, they're short and sweet, and then maybe foreshadow one future case. The first one is Bonter versus Progressive. It's a case that was decided in an order, and as Chris, highlighted earlier, an order with explanation from the court is just as good as an opinion. This opinion is interesting for a few reasons. The first is that it was a 3-2 decision. Justices Thomas and Hood, the most recent justices, did not participate in the case and didn't cast a vote. Would have either Justice Thomas or Justice Hood shifted the outcome? Who knows? It's possible it could have made it 3-3 or 4-3. And I think that's important because given how the premises liability decisions unfolded, that the lack of a full bench can really have significant consequences. I think with hindsight, it's safe to say that had Justice Welsh participated in a case called Livings, which was issued in either 2020 or 2021, it's possible that the Livings case would have overruled open and obvious doctrine in advance of El Said, which only came, 2 years ago. Justice Welsh did not participate in Livings, didn't cast a vote, and she might have changed the outcome because she did sign on with the El Said majority a few years later. So it's something to keep an eye out is how do Justice Thomas and Justice Hood view the issues that were involved in Bonter. They could swing that vote in the other direction down the road. The Bonter case is pretty narrow holding. The dispute was whether the insurance policy at issue there was subject to the new requirements for third-party liability in auto insurance policies under Section 3009. The statute says new third-party liability levels apply to policies issued or delivered on or after July 2nd, 2020. Two different Court of Appeals opinions interpreted that language as what I think is a fair read, that the new liability standards only apply to insurance policies that were renewed or issued after that July 2, 2020 cutoff. The Court of Appeals opinions held that policies issued prior to that date were not subject to the new rules. The plaintiff's view in the Bonter case was that any policy in existence on July 2nd, 2022 automatically converted to the new 3009 third-party liability standards, whether the insurance company accepted additional premium to account for the higher exposure, whether the policyholder filled out an application for these new levels, automatically switched. DIFS, I mentioned this earlier, DIFS issued guidance, the Department of Insurance Financial Services, agreeing with essentially Progressive's view and what the Court of Appeals held in Bonter and another case called Pena, that the insurance policy do not automatically convert on July 2nd, 2022. It's only when a new policy is issued or renewed after that date. DIFS agreed with that view. The Michigan Supreme Court majority in a 3-2 opinion disagreed and said, we respectfully disagree with DIFS. We're not going to follow DIFS guidance. We're going to interpret the statute how we think we should. There was a dissenting opinion. This one's interesting for a couple of reasons. It was Justice Zara and Justice Welsh together who disagreed with the majority opinion. Unlike Justice Zara's 62-page dissent in Rayford, one of his colleagues joined him here. They agreed with the Court of Appeals opinion, and they also specifically noted something that we've all encountered, that the statute was not a model of clarity and that they were really struggling with how to interpret it. So that's the holding in Bonter. One other previous case from the previous term, C-Spine versus Progressive and Wallace versus Smart consolidated cases. Again, narrow holding, and the holding itself is not super firm. There's a lot of further development in those two individual cases and the law in terms of what exactly the case means. The opinion held that standing is a distinct concept from real party and interest. And in the C-Spine and Wallace cases, the court addressed cases where an individual, in Wallace, it was an individual involved in a motor vehicle accident. She assigned her right to payment for her medical treatment to her medical providers. In C-Spine was a medical provider, which now has a direct cause of action against an insurance company if it treats an individual injured in an automobile accident. C-Spine sold its accounts receivable, hundreds and hundreds of thousands of dollars. There are multiple C-Spine cases because C-Spine followed this model in a number of cases, selling the right to collect on these medical bills to factoring companies that have nothing to do with auto insurance, medical providing. Again, they're factoring companies. Both C-Spine and Ms. Wallace assigned their claims to other parties, but then filed suit anyway and found their cases dismissed or treated differently, saying, no, if you assign your claim, you no longer have a claim, you don't have standing of every party interest. The Michigan Supreme Court tried to offer some guidance on what those two standards meant. The court held that although the C-Spine was not the real party interest when it filed suit, that defect can be remedied after the fact. And in that case, C-Spine, the factoring company, had counter assignments and revocation of assignments and all sorts of other mechanisms to try to reinstate the claim. Similarly, in Wallace, they looked at it a little bit differently. In Wallace, she and her medical provider, sought to rescind the assignments and deem them void from Jump Street. And the court held that the analysis for Ms. Wallace and her medical provider would be a rescission analysis that's a little bit different than the how they handled the C-Spine assignments. That case, again, narrow holding, tough to get a full grasp of what it actually means until the lower courts sort out the rationale. And then the final case I was going to discuss is it's a Court of Appeals decision, but I think it's foreshadowing a potential Supreme Court challenge. The case is a state of Kenneth Pionk, I think it's how it's pronounced, Pionk, I'm not sure, against Harper Hudson Hospital. Published Court of Appeals decision, the first one I'm aware of interpreting and implying the Daher decision, which was, again, last year's groundbreaking opinion. The opinion was just issued in July. It's very new. No further appeal has been filed, but I'm going to guess the hospital is probably going to seek leave to appeal in the Michigan Supreme Court. It's a major decision. The Court of Appeals addressed two separate questions: whether taking one step back, the facts of the case. It's a tragic, horrific case, sad case of a newborn that died a few days after being born, and the newborn's family sued the hospital, blaming the hospital for the baby's death. The two issues in the case were whether the estate of the deceased newborn can seek earning capacity, lost wage damages down the road. And then secondly, whether the estate can seek loss of household services that the baby would have provided to the parents and other family members. Okay, so the Court of Appeals held that the Daher decision controlled issue number one, but not issue number two. So the court held no loss of earning capacity, no lost wages for the estate of the deceased newborn. Daher clearly ruled that out. But what the court held was Daher did not clearly rule out the loss of household services that the estate could claim. And just anecdotally, this is a different treatment than what I have seen other lower courts do. Other lower courts seem to be strictly applying Daher and the holding of Daher, that if the damages that are sought in a wrongful death case are not specifically and expressly identified in subsection 6 of the statute, they can't be recovered. That seems to be how most lower courts are deciding these other issues. Court of Appeals did not see it the same way. The statutory language does not reference household services anywhere in subsection 6. But what the Court of Appeals held anyway, despite that holding of Daher, they looked to the historical treatment under Michigan law and how prior Michigan Supreme Court benches and other Court of Appeals opinions have addressed the household services issue in the past and elevated historical treatment of household services over the statutory language, which seemed to be the focus of the Daher opinion. The court also rejected a defense challenge that the recovery of household services for a newborn baby that no one knew what the skills would have been, what they would have been like, who their family members would have even been 18 years down the road was too speculative to recover. And the Court of Appeals rejected that argument and said that all wrongful death damages to some extent are speculative because the person's not around anymore. So you always have to kind of project into the future. There's always going to be some level of speculation, wrongful death damages. And they said it was not too speculative to happen here. So I'm sorry, to allow them to go forward here. Again, this opinion is issued just over a month ago. There's still time to go to the Michigan Supreme Court. Hasn't been filed yet. I would guess it's going to be filed. I think it's going to be an opportunity for the Supreme Court to further clarify the Daher decision. And I will close with what I think is the money quote of this opinion. It's on page 8. And it explains how the court arrived at this conclusion, despite Daher, that these damages would be allowed. Because, there's a couple other reasons why the court was asked not to allow household services. One is that the basis of household services recovery in wrongful death is a case called Thorne, a Michigan Court of Appeals decision that Daher specifically overruled to the extent it was inconsistent with Daher. And again, Thorne allowed household services in a wrongful death case. It was like $1.5 million. So it's a major issue. Supreme Court said we overrule Thorne to the extent it's inconsistent. And I think what this panel in the Pionk case, how they interpreted that statement in Daher was that Daher overruled the rationale, the reasoning of Thorne, that the listing of damages is illustrative, it's not exclusive, it just provides some examples. That was how Thorne came to its conclusion. And what this current panel said was Thorne's rationale was overruled, but not necessarily the holding of the case, the conclusion the panel reached. And that's, again, walking a very fine line, but that's how this Court of Appeals panel interpreted Thorne and Daher and the statute. And with all that build up, the main quote is on page 8. After quoting a number of experts of Daher, the panel held, while these experts standing alone support that the WDA's list of damages is exhaustive, we think that in context, these portions of Daher mean only that by using the word including in the damages provision of the WDA, the legislature did not intend to expand the types of damages available under the Act to damages that had never historically been available under any version of Michigan's Death Act. The issue presented by this case then stands in stark contrast to the issue in Daher. Again, damages for loss of household service have been available under every version of Michigan's Wrongful Death Act since the first Death Act was enacted in 1848. So again, the panel specifically elevated historical understandings of the Wrongful Death Act over the plain language of the statute, which again, in my view, was the focus of the Daher decision. Still a few weeks away from the deadline to file an application for leave to appeal. Remains to be seen if it's pursued. If it is, that might be something we're talking about next year.
Thank you, Tim. Do either Beth or Chris have anything to add?
I was just going to add one additional case that that the Supreme Court has granted. I think it's a MOA, but I have to double check that. Yeah, argument on the applications. It's a case called Harris versus Beaumont Health. In this case, it's a really interesting, I think for purposes of this group, I think it's an interesting issue because it's a lot of procedural anomalies, I think. So the real issue, the issue that the Supreme Court is going to look at is whether Dean versus Tucker factors apply to naming a new expert witness. So the facts in this Harris case, the plaintiff ID'd an expert witness, Dr. Ball, and then filed an affidavit of merit by Dr. Ball with their complaint. Dr. Ball ultimately cuts off communication with the plaintiff. The defendant gets an order compelling the deposition of Dr. Ball. Dr. Ball, because he had not shown up for a couple of the depositions, that order to compel was granted. So because Dr. Ball had kind of fallen off the face of the planet, the plaintiff filed an amended expert witness list. The trial court struck that expert witness list, saying that it wasn't procedurally proper. The timeline for filing the witness list had actually passed at that point. Trial court basically said, you got to follow procedure. So the plaintiff's attorney then follows the procedure and files a motion to amend the witness list, and the trial court says, no, you can't do that. It's too late. There's prejudice to the defendant because in part, mostly, I think, relied upon the fact that there was close of discovery at that point, which wasn't actually accurate. The trial court had entered an order that had extended discovery prior to that, but didn't make any reference to that fact in its decisions. The plaintiff then moved to voluntarily dismiss the case because they had no expert and they had no ability to name a new expert, even though they had identified this new physician who was willing to act as an expert. The court denied the motion to voluntarily dismiss the case and said that there was prejudice to the defendant because they had been litigating this case for some time and they had time and money that they had put into the case. So the court then grants summary disposition, not so much because there's no expert there or there was a violation of a court order to compel the deposition of the expert, but because the affidavit of merit that was filed by the initial expert, Dr. Ball, was deficient or defective. Because the defendants had found some information out about Dr. Ball that would indicate that he was not in fact qualified to sign this affidavit of merit. Now, all of this took place long after the timelines in the court rules for when you have to challenge affidavits of merit. There is no reference to that at any point, even in the Court of Appeals. So the court grants summary disposition based upon a defective affidavit of merit. And the Court of Appeals reverses, ultimately said that the trial court had abused its discretion in failing to allow an amendment of the witness list without first considering the factors that are set forth in Dean versus Tucker. It held that witness lists are an element of discovery, and that if you're going to make a ruling that's going to basically result in summary disposition, then you have to have at least a discussion regarding these Dean versus Tucker factors. I think everybody's familiar with them, but you have to look at the prejudice to the defendant, a prior history of delay, a prior history of failing to comply with court orders, those types of things. So they remanded the case back to the trial court on that. As to the summary disposition issue, they did reverse the grant of summary disposition as well and said, it was premature, essentially, that there was discovery was still going on. The plaintiff had attempted to name a new expert and, mentioned in there too that, case law says that you can now file an amended affidavit and that would relate back, and the plaintiffs have a new expert and they might be able to do that. So now it's interesting. The Supreme Court has granted a MOA, and the question that they say that they want addressed is whether the circuit court abused its discretion when it failed to consider the factors that are set forth in Dean versus Tucker during the consideration of the plaintiff's motion to amend the witness list and add a new expert. So that is one of the issues that the Supreme Court is going to be taking up. I assume it'll be this term. And, so I think that's kind of one to watch because that does affect both plaintiffs and defendants. Everybody has an expert that, completely disappears or maybe completely says, you know what, I now looked at things and I can't support your case. I think everybody's big concern about what could happen. And, so the Supreme Court is now going to look at this issue. There's another case that was similar facts that they held in abeyance pending a decision on this case as well. Where that exact thing happened. The witness said, I received additional information and I don't think that there's any issue here, any problem with the care and treatment. So, under what circumstances should litigants be allowed to amend witness lists? So that's a big deal, obviously, for everybody in this section.
Beth, what did you see the Supreme Court granted a MOA?
MOA,
And what's the
yes.
name of the case? I mean, this issue pops up all the time.
Yeah, it's called Harris versus Beaumont Health. The order was just issued on June 11th of 25. The case numbers, it's 167716 and 167720.
Excellent. Thank you, Beth.
Yeah, absolutely. I know I just popped that one in there, but I don't know why I didn't throw it in there before. So
Well, like you said, that's an issue that affects both sides
absolutely.
routinely. And it is absolutely nightmare fuel as a trial court lawyer to think about, you know, if my expert goes south late in the game and the judge isn't willing to play ball, boy, I'm in trouble, you
Yeah.
know. So no,
Nobody
very
wants their case dismissed and nobody wants to end up in default. That's all there is to it.
sure, absolutely. Um, I just looked and our chat section is empty, which means that you guys must have explained every case sufficiently. We can give it another second here, but so far no questions. Seeing none. All right, we're just a couple minutes before our end time of 1:30. You guys were able, obviously, to fill the time. Never a concern with a panel of three appellate lawyers, right? Always more to chat about. So, to our panelists, thank you. We appreciate your time. All of you guys give generously to the section over the years, and we very much enjoy your expertise, your knowledge, and your generosity to share all of that with us, our members, our attendees. I'd also like to thank Chad Engelhart, who's being shy and hiding behind his screensaver up there. Are we going to see him? He's thinking about it. There he is. Our education czar always has a hand in programming, always does an excellent job. Let me make a pitch, Chad, if I may, on your behalf. I believe our next educational programming will be October 7th, right? At the MSU Troy Outreach Center. I think I'm not saying it exactly right. The MSU Extension Center that's in Troy. We've had a number of other events there. This will be more educational programming. Look for all of our members. Please look for the advertising of that in your emails. It will be, if it hasn't happened yet, will be happening soon. We ask each of you to consider attending that or sending members of your firm to attend, much like you have today. And then finally, thank you to our members, to everyone who's attended today. We couldn't make these things we couldn't put these programs on without joining the section, without keeping our numbers up when we do put them on. So, for everybody that has tuned in today, on behalf of the negligence section, thank you very much. You'll be seeing more from us soon, and we hope to bring you into future events.
And thank you, Mark, for pinch
Yeah,
hitting.
thank you, Mark.
Thank
Excellent
you
job
very
by
much,
all.
Mark.
All right. Take care, everybody.
Okay, thank you.